Friends, in the last video, how to send representation, how to draft representation, and to whom the representation should be addressed, and how the representation is disposed of by the concerned authorities and advisory board has been discussed. I have also promised you to upload a video on the writ petition, which is to be filed in High Court or Supreme Court, as the case may be, under Article 224 of the Constitution and Article 32 of the Constitution of India, respectively. Today I am going to discuss how the writ petition has to be filed before court. Before dealing with how it is filed, it would be pertinent to deal with the writ of habeas corpus, which is under Article 226 of the Constitution of India. Now, writ of habeas corpus is a writ which means that bring the body. It is a writ by which the court is empowered to ask the authorities to bring the person who has been detained and to produce him before the court in order to let the court know on what ground he has been detained and set him free if there is no legal justification for the imprisonment. The writ of habeas corpus was regarded in England as foundation of human freedom, and British citizens insisted upon this privilege whenever he went, whether for business or colonization. This is how it founded a place in the Constitution of United States when the British colonies America won their independence and established a new state under the US Constitution. In India, the power of issue a writ of habeas corpus is vested only in the High Court and in the Supreme Court. Habeas corpus is a writ which was visualized as an effective means to provide a quick remedy to a person who has lost his personal liberty without any legal justification. Therefore, it cannot be used for complaining against past illegal detention. But the Supreme Court in India has explained its dimension and comprehension is being paid not only for past legal detention but also for loss of life. Initially, the state was asked for compensation to the prisoner if he was illegally detained. But now the payment are ordered to be given as compensation. Probably done for the reason that a regular civil suit or damages for false imprisonment, the state may successfully put the defense of sovereign immunity. Detention should not contravene Article 22 of Constitution of India. For example, a person who is not produced before a magistrate within 24 hours of detention is entitled to be released. The power of detention vested in an executive authority, if exceeded, abused, or exercised malafidely, make the detention unlawful. Article 21 of the Constitution of India declared that no person shall be deprived of life and liberty except in accordance with the procedure established by the law. Therefore, a machinery was required to examine the question of illegal detention with utmost promptitude. The writ of habeas corpus has thus been described as a writ of right is grantable ex debito justitia. When physical restraint is put upon a person under a law, there is no right to habeas corpus unless the law is unconstitutional or the order is ultra-vires to the statute. Now I'll discuss when a writ of habeas corpus would lie. The writ of habeas corpus is available as a remedy in all cases of wrongful deprivation of personal liberty. It is a process of securing the liberty of the subject by affording an effective means of immediate release from unlawful or unjustifiable detention, whether in prison or in private custody. The Constitution confers appellate power on the Supreme Court and all the high courts in India in the matter of issue of writ habeas corpus. The right to move Supreme Court under Article 32 for the enforcement of fundamental right is itself a fundamental right, while the right to move a High Court under Article 226, though not a fundamental right, is still a constitutional right. Now, the question arises where habeas corpus does not lie. The habeas corpus remedy is available in all cases of wrongful deprivation of personal liberty, but the writ of habeas corpus will not lie when the person or authority against whom habeas corpus is sought is not within the territorial jurisdiction of that court, meaning thereby that Bombay High Court cannot issue a writ of habeas corpus if executive authority is situated out of Maharashtra, who has issued the detention order, or when a detention of a person is in accordance with a decision rendered by court of law or by any authority in accordance with law. Now, whether writ of habeas corpus would lie during emergency, you all are aware that emergency was imposed on India on 25th June 1975 under Article 352 of Constitution. Prior to 1978, that is before 44th Amendment in the Constitution of India, the President could suspend the fundamental right, including the right of personal liberty, When Article 21 was suspended, it was held in Additional District Magistrate Jabalpur versus Shukla that an order of preventive detention could not be challenged even if it violated the Parent Act. The 44th Amendment in 1978 has provided that Article 21 relating to personal liberty cannot be suspended even during emergency. This way, personal liberty has been strengthened and the writ of habeas corpus retains its potency even during emergency. Now, once writ of habeas corpus is filed, what is the role of the court? Court will issue Rule Nisi. What is Nisi? Nisi means unless. At the first hearing on the writ of habeas corpus, if court is prima facie satisfied that the prayer deserves to be granted, it may issue Rule Nisi and call upon the person or the authority against whom such writ is sought to file a return on a particular day, showing cause as to why rule should not be made absolute and the person, should not be released from detention or confinement. Now, once rules are issued and after hearing the rules are made absolute, then question of res judicata will apply. If there should arise an occurrence of writ of habeas corpus, it is held that it is generally settled that no second writ of habeas corpus or appeal on the same ground is viable. What does it mean? It means that a writ of habeas corpus or an appeal would lie on other ground but not on the ground which were taken in the earlier writ of habeas corpus. As far as the pleading is concerned, a strict rule of pleading does not apply in writ habeas corpus petition because the courts, whether Supreme Court or High Court, have shown great anxiety of personal liberty and never had refused to grant relief to the applicant merely on the ground of imperfect pleading. This is, in nutshell, the detail of habeas corpus. Now, the next question is how to file a writ of habeas corpus, when to file, what are the course of action after the writ petition is filed, and till the final decision of the respective court. Now, writ petition has to be filed after detention of the detenu, either himself or through his relative, his friend, his family members, or any person who has locus standi. Now, what is locus standi? If a person has been affected by the detention, and if he is interested in personal liberty and safety of the detenu, then he can file writ of habeas corpus. Now, writ of habeas corpus is drafted on the basis of the detention order, the grounds of detention, the list of documents, and the documents which were basis for the formulation of the ground of detention by detaining authority. All the material which has been furnished to the detenu while executing the detention order has to be carefully scrutinized, studied. Only then habeas corpus petition is to be drafted. Drafting is very important in writ of habeas corpus. You cannot simply say that this person is detained and he should be released from detention. So, to draft a writ of habeas corpus, expertise in detention matter is of utmost importance. Executive authority who has passed detention order and formulated the ground have got backup support, backup stop to help him. But the detenu who is confined in a jail does not have that facility. So, when a detention order is served on detenu along with ground of detention and list of documents and documents, the role of an advocate who is practicing in detention matter is very, very important. The advocate is supposed to know what are the fundamental right, what is Article 2 to 6 of Constitution, what is Article 32 of Constitution. Only then he can draft an appropriate and forceful writ of habeas corpus. The advocate concerned who is drafting the writ of habeas corpus should be conversant with the law, which has empowered the executing authority to issue detention order. That is, if a person is criminal and is nuisance to the society, National Security Act is invoked and an order of detention under NSA is passed by the executives. Similarly, if a person is indulging in smuggling activities, then he is violating Section 111, that is import, or Section 113, that is export of the Customs Act. Once these two sections are contravened by the detenu and the goods are liable for confiscation, only then Conservation of Foreign Exchange and Prevention of Smuggling Activities 1974, that is CAFE-POSA 1974, comes into play. So an advocate who is conversant with the criminal law, which are backbone of the detention order, or customs law, which is backbone of CAFE-POSA detention order, only then he would be in a position to draft a forceful habeas corpus petition. I will deal with various aspects of writ habeas corpus in next video. In the meantime, it is again requested to please subscribe to my channel and share it as much as possible to motivate me to bring more such videos for the benefit of the normal citizen, students of law, officers who are interested with issuance of detention order, and practicing advocates.